Hello everyone, welcome to English Shorthand classes. Exercise 9. Get ready for the dictation. Start. The factual matrix of the case is that the plaintiff respondent filed a suit against the defendant appellant for recovery of possession and damages, alleging that she had purchased the suit property out of her own fund and she is the absolute owner, but part of the property was under the illegal occupation of the appellant defendant, who opposed the suit, contending that the suit property was a Hindu undivided family property having been purchased in the name of the respondent using the funds of his grandfather, father, and himself, and not purchased by the respondent, as she was a housewife having no income stock. The appellant defendant further pleaded that though there was a dispute regarding his ownership and possession, the same was settled between all the family members via compromise deed dated 22/10/1997. Stop. The respondent filed an application under Order 12, Rule 6 of the Code of Civil Procedure for passing a decree in her favor on the ground that a suit for partition, which had earlier been filed by the appellant on the same ground, that is, that the suit property was a HUF property, had been dismissed by the District Court wide judgment dated 8/9/2003 and affirmed by the High Court wide judgment dated 12/9/2011, and the respondent contended that the same amounted to an unequivocal admission by the appellant that the respondent was entitled to possession stock. The trial court held that though the judgment dated 8/9/2003 of the District Court and judgment dated 12/9/2011 of the High Court had rejected the plea of the appellant that the suit property was a HUF property, these findings were made in a suit for partition, whereas the present suit was filed for recovery of possession and damages stock. The trial court further held that for passing a decree under Order 12, Rule 6 CPC, the defendant had to make an unequivocal and unqualified admission stock. The appellant herein has not made such an admission regarding his liability to pay the damages claimed by the respondent stock. The trial court dismissed the application wide judgment dated 7/6/2013 stock. Aggrieved by the judgment of the trial court, the respondent filed a revision petition before the High Court stock. The High Court, while allowing the appeal and decreeing the suit with costs, held that the pleas taken by the appellant defendant regarding the contribution made by his grandfather, father, and himself in the purchase of the suit property had been rejected by the High Court wide judgment dated 12/9/2011, and the same will operate as res judicata stop. The High Court further held that while there was no evidence for holding the suit property to be a HUF property, the title deeds of the suit property and the land records stood in favor of the respondent plaintiff stop. The High Court noted that the only new plea taken by the defendant in his written statement was that he was a co-owner wide compromise deed dated 22/10/1997, and held that this plea was barred on the grounds of constructive res judicata, having not been raised earlier in the petition suit filed by the defendant stop.